Good afternoon, everyone. My name is Lauren Toussaint, Executive Director of PrivacyRules. Welcome to this webinar series. This is the second in the PrivacyRules webinar series. The first was on data transfers and is available on the PrivacyRules website, privacyrules.com. Today, we will be discussing data protection officers and EU representatives under the GDPR. We have with us three member experts: Stefanos Simakalis from Simakalis Naru law firm in Greece, Marcus Mirberg of Lexia Attorneys in Finland, and Mike Natardi of Frost Brown Todd in the US. Mike Natardi will act as a mediator today, providing us with a US perspective, having spoken with US clients doing business in the EU and asking themselves these same types of questions, whether or not they need an EU representative or a data protection officer under the GDPR in the EU. So without further ado, I will hand it over to Mike Natardi of Frost Brown Todd. Mike, over to you.
Thank you very much, Lauren. It is a pleasure to be here with you and with the others. It's also a pleasure to be a part of PrivacyRules, the collaboration between professionals throughout the world, both for legal issues that have to do with privacy and also that have to do with the technical questions surrounding those as well. As a little bit of a background, I'm an attorney here in the United States, and I help clients of all sizes with their questions regarding privacy and the compliance with that, whether it has to do with complying after a data breach or in keeping them within compliance, having to do with following regulations like the GDPR, soon to be the California Consumer Protection Act that's going to be coming into effect in January. And this is a very interesting topic for us because the fact that a lot of the clients that we have over here, I would say already fall into one or two categories. And then I'm going to talk about the third one, which will get us into this conversation. The first is that they knew from the very beginning that the GDPR was going to affect how they were doing business, that the place that they were doing business in the EU, that they were going to have to get all their ducks in a row before last May, okay? And so those types of clients are usually the much larger clients that have presence throughout the world, not just in the EU, but all over. And those types of clients, frankly, we don't have very many. The ones that we do have made these decisions long ago. The second type of client that we have is your more medium-sized, let's say 500 or less employees that have a potential presence in the EU, and they do like doing business with the EU and getting sales from the EU. However, they're not really sure about the legal space. And so with that, whenever they want to ramp up and do more in EU, that's when we get the phone call, is that we have this decision to make on whether or not we're going to invest more or we're going to just stay where we're at. And that's where the context of this discussion when come up with our clients is going to be, you know, I've done some reading. I know that we're going to, you've said, let's just use a hypothetical that we've talked before about the work that we're doing in the EU, and we're either not caught up in the GDPR because we don't qualify under the definition, or we're not doing enough work over there. We now want to do what you've warned us about. We want to invest more. We want to go all in. Now, do we need a DPO? Do we need an EU rep? And what does that mean? And so those are the clients where it's great that we have this collaborative so that we can get the more input from our EU members. And really the first thing that I think that we should be starting at would be what is an EU rep? And how does that relate to all of this to clients that might be saying, look, we've put this off long enough. Now we want to comply. We want to do more business in the EU. Do we need an EU rep? Do we need a DPO? And so I guess with that, I'll turn it over to Marcus and ask him to jump in.
Yeah, all right. Thank you so much. It's a pleasure to be here in this webinar and to present some views regarding the EU representatives. And it's a very interesting question, actually, which was raised quite many times up when Privacy Rules just had a conference in Beijing, and it was also an interesting topic to also, for example, the Chinese companies. And regarding the EU representative, I think that most companies outside the EU have to designate or have to have a EU representative who is a person or organization established inside the EU. If the company outside of the EU doesn't have anybody in the EU represent him. So officially the term is if they are not established in the EU, then you actually, and you fall into the territorial scope, and so you are processing the information of data subjects who are in the EU. So in very generic, saying in a very generic way, so this is the case. If you are not here in the EU and you process and you offer goods and services in the EU, you need somebody here. Of course, there are some other qualifications there, but I think we could discuss a little bit more that in detail. So, but having EU persons who are staying in the EU, their information, offering goods and services, and monitoring their behavior in the EU, then you need an EU representative.
So it sounds like to me that if you're, and you know, obviously we're going to have people watching this that aren't from the U.S. perspective, and so I don't mean to monopolize and don't want to take over, but since that's kind of like with the thought that we started, it sounds like to me that if you have a client that's going to, let's say, come to me and say, you know, Mike, we talked last year about the GDPR. One of the things, let's say, that they wanted to get involved in was getting some information that had to do with, that would collect some background check information, especially potential criminal history information. And we decided, you know, Mike, last year that if we're going to dive into it, it's going to just be too much of an investment. Now we need to take that step. And so, but they say, hey, we don't have a presence over there. This is going to be all done electronically. It seems to me that that's the perfect instance that there would need to be an EU rep. Is that correct?
That's correct, and actually that's quite many times also. Most of the companies might even not to want to have any branch or representative office area, mostly because of the tax reasons. So you try to avoid to have any established in the EU. But that's of course totally different situation if you collect or anyhow have or do any background checks, and then you actually, as you said, you need somebody here. At least the lowest level, of course, is to have EU rep, and then of course the other option is to have a data protection officer. We will talk about that a little bit later.
Yes, then that's a great segue, actually. I think for us to bring Stefanos into the conversation, having to do with the DPO. And so, you know, just keeping this hypothetical going with the client that comes to me and says, okay, now remember that conversation, we weren't ready, now we're ready, we want to make this investment. So we know that we need a EU representative. And I guess we'll come back to exactly how we get one. But Stefanos, if you could, I think that we're probably going to need a DPO as well. Will you let us know a little bit about what that means and what we're going to have to do?
Sure. Very glad to be here as well. So the Data Protection Officer is a new role that was introduced by the General Data Protection Regulation. It's in essence a person with expert knowledge of data protection laws and practices, and the ability to support and advise the data controller or data processor in connection to their obligations under data protection laws and GDPR in particular. There are no specific requirements as to the background or education that the DPO should have. And in essence, anyone could assume that role, provided that they are well versed in data protection laws. So it could be both lawyers or IT specialists, provided, of course, that they do not have a conflict of interest. And that's a very important topic because in an organization, in an organization, the DPO can be internal or external, but the problem or the issue that many companies face with appointing internal DPOs is that they often are conflicted in the sense that they have a say or a role, a decisive role in matters of data protection, and they shape the business's policy in connection to that. If the DPO is external, that could be on the basis of a service contract. And of course, the DPO, and this is very important to know, does not take instructions regarding the exercise of his or her tasks. That means he or she should enjoy full independence, and their presence is more of an advisory nature. They do not decide about the means or purposes of data processing, but rather provide their view and advice to the business. And of course, that means also that the DPO enjoys a certain immunity because he cannot be dismissed or she cannot be dismissed or penalized for giving an advice that is contrary to the business's view when it comes to the protection of personal data. And of course, and this is very important to know, the DPO should report directly to the highest level of management, even in certain instances directly to the board of the business.
Okay, so I hate to come back to this, this hypothetical kind of situation, but I think it is helpful in kind of explaining to people, the thought process that we as attorneys and as advisors for companies might be going through. So it seems to me in this hypothetical that if I have this client that comes to me and that wants to do more work in the EU, and we discussed that it is going to be using in collecting background information, potentially criminal check, information or criminal history information, which is a special type of information. So would that automatically put my client into an area where they would need to get a DPO?
Well, not automatically. Further consideration should be given to the topic.
Okay.
I mean, the General Data Protection Regulation provides 3 explicit instances where a controller or data processor should appoint a data protection officer, and the first one being about if the processor or controller is a public authority or body. So right. In that case, that plays a decisive role. Or, and this is where the hypothetical comes in, if the core activities require large-scale, regular, and systematic monitoring of individuals. So if the business we are talking about does collect criminal records on a systematic, large-scale basis, and does that, so if the collection of the criminal records, let's say, is part of the business, then they should definitely appoint the DPO.
Right.
Another example is online behavior tracking or behavioral advertising, whereby large-scale, regular, and systematic monitoring of data takes place. And the third explicit instance where a DPO should be appointed is where the core activities of the controller or processor consist of large-scale processing of special categories of data. So, for instance, health data. And of course, what we are talking about here, data relating to criminal convictions. So if again, this is a core activity, then this business should definitely appoint a DPO.
Right, and that is a very interesting area of information to be collecting. And I'm sure that all of us as attorneys would be asking our clients, "Are you sure you need this information?" Going back to the whole, why are you collecting it? Why are you using it? And are you sure you need it? So let's say that in this conversation with the potential client or with the current client that wants to expand their business and their investment in the EU, that it's clear that they need this information for whatever purpose that they need it, and that it is going to be a part of their business. And they do not have an establishment and are not established in the EU. So we need to get them into an EU representative. How would you advise, and this is open to both of you, how would you advise that we go about finding the right EU rep and the right DPO? Who can, number one, who can be a EU rep, and then who can be a DPO?
That's a good question. Yeah, and of course, so basic requirements for the EU rep is that he or she can be a natural person. Or normally, of course, it's more usual that they are legal person and must be located in one of the EU member states, and where one of those states where the personal data is processed. So that's like the minimum requirement. And I think that at least in Finland, we have different kind of firms providing the services. We as a law firm, we have provided the service for certain clients, and it's always case by case. And there are also some other firms type of specialized in privacy and data protection without being even law firms, and they also offer these kind of services, both the DPO and rep services as a service. But actually the official requirements for the representative, which is like the little bit low level of the person or the entity you must have in the EU. So the requirements are not too heavy, but of course, because EU rep is meant to serve as a contact point especially for the local authorities. So sure, the contact point has to have some kind of knowledge what to do, and because EU reps they themselves have some responsibilities. So I think it's not even it's not so good idea to act as a EU rep without knowledge and education about the GDPR good enough. And actually the role of EU rep is a pretty passive, more like keeping the records of the processing and acting whenever he or she is asked to give some information or to act as the actual contact point between the non-EU controller and the authorities or the data subjects in the EU. So it might and it has been so far a little bit easier to find EU representatives than, for example, DPOs, because of those questions Stefanos already raised up, the conflict matters, and of course the role and responsibilities of DPOs are much larger than EU reps. But anyway, shortly, they are. You should ask around in the relevant states or the relevant EU countries where you process, where your clients or where you offer the goods and services.
That's fantastic. And so I think that leads us into the next question with Stefanos, has to do with who can be the DPO, and should it be somebody different than your current legal counsel because of the conflicts that you said earlier? And then finally, also given all the responsibilities, what about payment? And then the last question I think is going to be for either one of you is is that can, technically, we can always say technically, but it doesn't mean that it makes sense. But technically, can the same person fill both roles? Can someone or entity be the EU rep and the DPO? So Stefanos, I'm sorry to throw that much your way, but if you have any thoughts on any of those issues, it'd be greatly appreciated.
Sure, I would start with the last question. So could a person be both an EU rep and a DPO? I would say if a business is looking what to do, probably appointing a DPO is something that covers the need to have an EU representative, because the DPO has a much broader scope of work, and in essence the role covers pretty much what the EU rep does as well. One of the main functions being acting as the main contact person for the data protection authorities, various data protection authorities of EU member states, and acting as a contact person for data subjects, which is very important. As to the qualification of the data protection officer, if the external legal counsel can be the DPO, I would say in essence yes, but then there's also the question, what happens if a case reaches courts? So you have a data breach and then subsequent litigation. In that case, the data protection officer would have to turn to a different law firm to represent them in court, because you wouldn't be able to act for the business in that regard.
Does so I think that it's pretty clear that the EU rep would have to be in the EU, because that's the whole point of the establishment. But what about the DPO? Does the DPO have to be in the EU?
I would say that the data protection regulation provides that the DPO must be accessible. So it's highly recommended in that regard that the data protection officer is located in the EU, regardless of the actual establishment of the business or of the data controller or processor. This is very important, both for the relationship of the DPO with data subjects and supervisory authorities. So I would say yes, that the DPO should be located in the EU.
So it's probably a best practice, but is it fair to say that it's not required by the GDPR?
Well, it's not written in the GDPR.
Right.
Yeah.
Right.
EU rep, he has to be in the EU, as you said, and because he's the local mailbox type of, so somebody to reach to give the sanctions or to contact the
right.
EU processor or controller.
So what we have here is under this circumstance, I can say that's probably a really good thing for privacy rules, because it's going to be very easy for me under this hypothetical situation, because I'm going to contact, one of you all, depending upon, where the primary activities are going to be taking place, and, the number of, let's say, potential EU users are going to be located. I think that it'll depend upon which, member of the privacy rules collaborative that I would contact. And so I think it's so much easy for us. But the question then that I would have is that for people outside of privacy rules, do they have any resource to find an EU rep or a DPO, or is it going to be much more difficult for them if they don't have a privacy rules connection, or the law firm's not in privacy rules? They would still have to find it on their own, would they not?
Yeah, sure. And I think it's not. I've heard that it's not always that easy to find. If that was the question, it's actually not too easy to find even the EU reps. So because of course about the liabilities but of course you can agree, and of course the written agreements between the non-EU company we are presenting, that we have to discuss about but we have to actually know who we will represent here, and they quite carefully try to do the assessment, or even though the role of the EU rep is little more limited than the DPO, but still there might be the risk to face too many questions from the authorities without getting any answers from our clients.
That makes total sense. What about the issue of, and this is a big concern, probably less for the hypothetical client here, not from their standpoint, but the potential liability from the EU rep or the DPO for the actions of the client. That's why I say where the client's probably not as concerned about it. But I'm sure that the potential DPO or EU rep would have some concerns about opening themselves up to liability for the actions of the controller or processor they represent. Do you guys have thoughts on that?
Sure. If I may go first. So
yeah.
I think it's very clear that the data protection officer does not have external liability. That means it's very clear in the GDPR that the data controller or processor remains ultimately responsible for complying with data protection laws, and that liability cannot be transferred over to the DPO. And there is a very good reason for that. The controller or processor should not limit his efforts in appointing a data protection officer and think, that's it, we're done with data protection compliance. We have now a DPO. To the contrary, as I said in the beginning, the DPO is an advisory, has an advisory role and responsibility for complying with the laws and the provision remains with the data controller or processor.
Yeah, and about the EU reps, so actually the representatives are responsible only regarding their own violation of their own obligations as such. So there are no expressly, so at the end of the day, so the foreign company always remains subject to legal actions and responsibility for any non-compliant actions they are doing. So you can't, so for the sanctions or administrative sanctions, so it is at the end of the day the non-EU or the foreign company, not the representative. But of course, as said, the representative will be there in the between, and the authorities will be in touch, and by that kind of involved anyway in the process. So, and that's why the reps are for the authorities to reach foreign companies more easily.
Makes sense. Makes sense. Well, Lauren, I've pretty much covered everything that I have on my end. I think that this has been a fantastic webinar in the sense that I think it's highlighted from my perspective why our privacy rules is so important. And just to hear these two speak has just been fascinating. I'm sure that I've left out some important questions. Do you have anything, Lauren, that you'd like to follow up on, or something that you think might be of more interest to our listeners that I've missed?
Yeah, no, thank you so much, Mike. You know, I think the only other thing that I would ask is, you know, I think you brought up a really good point earlier, and, you know, what should companies or, you know, people looking for EU representatives or DPOs, what qualities or characteristics should they be looking for? Because of course, I think we all know that there are a lot of companies that are offering these services, and there are nuances to the law, and it's extremely important to be careful because, you know, there is a lot of liability involved, and you know, I think you do need, I think that what we've heard from Marcus and Stephanos is that you do need to be careful who you choose. So so if maybe we could hear from each of you on just one final note on what to look for and sort of how to consider your choice in EU rep and DPO.
Okay, I can start it easier. So of course, even though the role of EU rep is more limited, but of course it's it's no use to have only mailbox in the EU.
Yeah.
You might need, or you might want to have a little bit more advice and practical advice and all kind of answers, even without asking all the questions.
Yeah, yeah. So obviously, I mean, in my experience, you know, if you are looking at sort of some of these companies that do just EU rep, I mean, at least making sure that they're being advised by attorneys, you know, for example.
So they have the level of knowledge good enough. So it's like, otherwise I don't see it. Of course, you can fulfill the minimum standards, but it depends on what you're looking for.
Yeah.
If
And
you're highly qualified yourself and you know everything about GDPR, then it might not be necessary.
Sure. And then I just had one final question on sort of the E-rep side, and then we can move to the DPO side. What about, can you insure against, because I believe this is an open-ended question. I mean, you can't properly insure against, I mean, E-reps themselves obviously take out liability insurance of sorts, but how does that work? If we could just touch upon it, or just so we could, you know, do you ask the question?
I don't have actual answers for that, so it's really a little bit open questions, and of course there are all kind of insurance for the EU reps possibly, but I'm not sure that for example in Finland we don't have an insurance for that. Your EU rep does what they have promised to do, so I don't know. It's still a little bit, as you said, open question.
Okay.
We will come back to that.
Yeah. And Stefanos, on the DPO side, what should one look for in a DPO?
I think the ideal data protection officer should have three key elements or characteristics. First of all, he or she should be an expert in national and European data protection laws and practices, and of course should display or have an in-depth understanding of the GDPR. Secondly, there should be a solid understanding of the data processors or controllers processing operations. That's very important. So a knowledge of the business sector in the broad sense is also required. And then, of course, he or she should be able to understand information technologies, data security, and some other technical aspects of that are key or essential for a solid data protection program in a business.
And just one final question for both of you is, how important is the relationship with the local authority? Do you oftentimes find that the people in this business have strong relationships or personal relationships with you know, people at the data protection authorities, or is that not so important?
Of course, it's partly, I don't know, in Finland, hard to say. Finland is a so small country, and I know personally the data ombudsman or the data authorities. It's of course good, but I don't know. It's a little bit difficult question. Depends on the case and country. In Germany, it might be a little bit harder to be a friend to the local authorities.
Yeah.
Not a friend, but no good enough.
Yeah, I think it does not play a decisive role. However, it is important that the data protection officer is someone who has some standing in the relevant sector, that makes the communication between the authority and the data controller or processor easier and facilitates the exchange of views between them.
Yeah.
It's been fascinating.
Great. Well, thank you all so much. Please don't hesitate to contact us at Privacy Rules if you want to hear more information about DPOs, EREPs, or our organization. So thank you again for tuning in to this second in the series of Privacy Rules webinars. And signing off. Thanks again.
Thank you so much.
Thank you. Thank you.
Thank you.